Are non-compete clauses legal in employment agreements? Imagine starting a new job and signing a contract that says you cannot work for a competitor or start your own business in the same field for a certain period. Sounds restrictive, right? Well, whether such clauses are legal depends on many factors. Non-compete clauses are parts of employment contracts that limit what employees can do after they leave a job. They are meant to protect a company's trade secrets and investments. But laws about these clauses are changing a lot. At the federal level, as of April 2024, the Federal Trade Commission has issued a rule that broadly bans new non-compete agreements in most industries across the United States. This rule stops employers from including clauses that prevent workers from seeking or accepting jobs elsewhere or starting a competing business after leaving. There are some exceptions, like for banks, transportation companies, or when a business is sold. Existing non-compete agreements for most workers are now considered unenforceable, but this could face legal challenges. On the state level, laws vary widely. For example, in California, non-compete agreements are illegal in employment contracts. California law explicitly states that such clauses are void and employers cannot enforce them. They also have to tell employees that any non-compete clauses are not valid. Other states, like Pennsylvania, requiring that non-compete agreements be reasonable in scope, time, and location. They also need to be supported by something of value, called consideration, like a job offer or a promotion. If a non-compete is too broad or signed after starting work without proper consideration, courts may refuse to enforce it. Some states have restrictions for certain professions. Healthcare workers, for instance, often face limits on non-compete clauses because of the importance of mobility in that field. Courts look closely at whether these clauses are fair and not overly restrictive. They try to balance protecting business interests with employees' rights to work and earn a living. Because of these laws, employers need to be very careful when drafting employment agreements. They must make sure their non-compete clauses are compliant with current rules to avoid losing their enforceability. Employees should also know their rights. If they see a non-compete clause in their contract, they should understand whether it is valid in their state and industry. In summary, non-compete clauses used to be common, but now federal and state laws are limiting or banning them in many cases. This shift aims to give workers more freedom to change jobs and start new businesses. So, whether a non-compete clause is legal depends on where you work, what the clause says, and recent legal changes. It's always a good idea to review employment contracts carefully and seek legal advice if needed.